Testing, testing, 1, 2, 3, testing, testing.
Yep,
All good?
I hear it. Yep, you're good.
Hooray!
Good morning, everyone. Welcome. Our first case for argument this morning is United States versus Robert Pennington. Ms. Small.
Good morning, Your Honors. May it please the Court. Carolyn Small on behalf of the appellant, Mr. Robert Pennington, Jr. During a traffic stop, officers are constrained by the mission of the stop. The Supreme Court made that clear in Rodriguez, where it said that in the absence of reasonable suspicion of other criminal activity, officers cannot prolong the stop beyond the initial mission. In this case, the officers had a hunch that Mr. Pennington was up to something, and they ultimately detained him for a combined 45 minutes for 2 minor traffic violations. They knew that they had no probable cause to search the car. They knew that they had no reasonable suspicion to delay the stop beyond issuing a warning. And when Mr. Pennington declined their request to search the car, instead of respecting his Fourth Amendment rights and complying with Rodriguez, they actively coordinated in an effort to find a way around those constitutional constraints. First, Sergeant Fleck initiated a stop and spent 25 minutes detaining Mr. Pennington for a speeding violation.
As you know, this is a very fact-intensive process, and so are we agreeing that there was a reasonable suspicion for the stop by Master Sergeant Fleck?
Yes, the first stop for speeding, and we are also not challenging the initial basis for the second stop that Sergeant Lillard made.
Okay, and so I don't want to try to truncate, where within the stop do we get traction that it's unreasonably delayed or prolonged?
So if we look at the second, I'll start with the second stop because that's the stop where the evidence was discovered. That stop is unreasonably delayed almost immediately because Sergeant Lillard starts running records checks that he knew Sergeant Fleck had just run within the hour. So he's running redundant records checks for information that he already knew. He already knew the license was valid. He knew registration and insurance were in order. He knew no wants and warrants. So while those types of checks in an ordinary case might be warranted, here, those were unreasonable, basically from the start. And Sergeant Lillard testified during the suppression hearing that he had all of the information that he needed to write the warning almost immediately. All he needed was the license, and if I can.
And so the lead system check is what we're testing the information he already had, registration. Did he have his name, the driver's name?
He did not have the driver's name, so that was the one piece of information that he needed to write the warning. He did need the information that was on the driver's license, but he had run the registration and the license plate before he even made the stop. So then when he stops Mr. Pennington, he's running his background, his criminal history, essentially, is what he's spending the time doing in that first 13 minutes of the stop, before he even opens his system to try to start writing.
But is that
the
not
warning.
also objectively reasonable under the cases? Running a criminal history for officer safety?
So typically, that has been considered reasonable. But this wasn't a typical stop, again, because of the first stop that Sergeant Fleck had just completed. Sergeant Fleck had just run that exact check, and it took a long time. When Sergeant Fleck did it, he said, Kentucky's running slow, and that initially, him running the criminal history check took a long time. And then he relayed to Sergeant Lillard that his criminal history said that there were trafficking for cocaine and for marijuana. So Sergeant Lillard already knew that. And he's pulled Mr. Pennington over for an improper lane change. So he knows, and Sergeant Lillard testified that he knew that there were no wants and warrants. So the officer safety component here is different than in a typical traffic stop, where officers are pulling somebody over. They don't know much about the car. They don't know who's in the car. They don't know that person's background. Sergeant Lillard is on different footing than a typical officer in a typical stop because he already has so much information that has been relayed from Sergeant Fleck. He also, so our position is that this stop was delayed almost immediately, but I think another very clear moment of delay here in the second stop is when Sergeant Lillard is he gets through these redundant records checks, he gets through the password issues to open up the warning system. He is ready. He's done everything he needs now to write the warning. And instead of doing that, writing the warning, he calls in another officer. He calls in Trooper Dorsey, who's not right on the scene. He's about 75 yards behind Sergeant Lillard. He has to drive up. And the only reason for that was to conduct a dog sniff. There was no mission-related reason why, in that moment, Sergeant Lillard couldn't just write the warning.
Ms. Small?
Yes.
Do we know when Officer Dorsey arrived at that location that is just some yards behind the stop of Pennington's car?
I don't think it's clear exactly at what point he arrived. Sergeant Lillard was keeping him in the loop and said, I found him. I don't know exactly when he arrived, but he was parked 75 yards behind him at the time that Sergeant Lillard called him to the scene.
Okay, and am I remembering correctly that Sergeant Lillard had been in touch with Officer Dorsey even before the stop occurred?
That's right. Yes, he'd been keeping him in, telling him northbound, I got him, so he'd been keeping him apprised.
I mean, one of the things that's a little unusual about this case is usually we see stops where the stopping officer is waiting for somebody to bring a dog and stalling or slow walking things. Those are the fact patterns or accusations. Here, Lillard couldn't do both, even though he already had the dog, right?
That's right, and he clearly was familiar with Rodriguez, that he said, by the time Trooper Dorsey arrived, he told Mr. Pennington, when Mr. Pennington said, why would you do a dog sniff? He said, because I can, and I'm not delaying the stop. So he clearly was familiar with this issue.
So, right, so what do we do? We've got, it looks to me from the district court's transcript like we've got a factual finding that seems pretty close to saying no delay in the second stop. What should we do with that, and on what basis?
So first, the district court really didn't address the redundant records check issue. And with respect to the delay in this handoff that happens between Sergeant Lillard and Trooper Dorsey, the district court does say, I find that didn't delay the stop in any way. I think there's two ways to read that. One is that it was a legal determination, that it didn't unreasonably prolong the stop for Trooper Dorsey to come in and do the warning. That wasn't unreasonable, and because it was a de minimis delay. And the court used the word de minimis multiple times and acknowledged, even if it was a 30-second to 1 minute delay, I find that to be de minimis and not unreasonable. So I think one way to look at the district court's holding is as a legal conclusion that this court can review de novo. And to the extent that was a factual finding, I think even the district court acknowledged there was some delay. The court said it was 30 seconds to a minute. If you look at the video and you line up the timestamps, you can see that it's really more like a 2 to 3 minute delay. So I think the district court's decision, whether it was a factual finding or a legal conclusion, is either clearly erroneous as a factual matter and legally erroneous to the extent that it was a legal determination that this was not unreasonable.
Can I take you back to the first stop by Sergeant Flack? Suppose, at least as I understand that, I didn't see any problem with that stop up to the point that the warning is issued. And I mean, yes, the records check was slow, but I don't know that there's much traction for you there. But we then have the questioning that continued for about 4 or 5 minutes after the warning, the documents were delivered. At that point, Pennington was still in the police car, correct?
Correct.
If we find that he was still in custody or that he was still being detained at that point, how would that extra 4 or 5 minutes have caused or contributed to either the second stop or any unreasonable delay in that second stop?
So those 4 to 5 minutes is when Sergeant Flack is he asks a number of questions clearly related to a drug investigation. He asks Mr. Pennington for consent to search the car. and in this period where he's unreasonably prolonging the stop. And Mr. Pennington says no, he denies consent, which he's entitled to do. And as a direct result of that, Sergeant Flack sends out messages to other officers saying, he says, crap, I just got denied. And he testified that that means I just got denied consent to search. And so as a direct result of he unreasonably prolongs the stop to ask for consent, then he uses the denial of the consent to inform other officers to look for Mr. Pennington and basically ask them to try to find a reason to stop Mr. Pennington, which Sergeant Lillard does. So, and Sergeant Lillard testified. It's a bit unusual. He testified, and there are messages, contemporaneous messages that he sends, that he was only out there looking for Mr. Pennington because he only stopped Mr. Pennington because he was out there looking for him. He says, I would have stopped 2 to 3 other people by now had I not been waiting to stop Mr. Pennington. So all of this is directly flowing from that unreasonably delayed portion of the first stop where he's denying consent. The officer is now looking for him only because of that. And then he finds him, and now we have this whole series of events as a result, and he conducts this dog sniff, which couldn't have happened if he didn't do this handoff to Trooper Dorsey. And I think if you take away...
But how do we, kind of moving back to the first stop, the government maintains that once the documents were handed back to Mr. Pennington, that converted that moment into this consensual encounter. How would you respond?
That is, I think, factually it's just not consistent with the facts. I mean, for it to be a consensual encounter, somebody would have to feel free to leave. And where courts, even where an officer hands somebody back their documents and has said, can I ask you more questions? Depending on the circumstances, courts sometimes still find that that's not consensual, although that moves the needle closer to a consensual encounter if an officer at least asks, can I ask you questions? That didn't happen here. Sergeant Flack never said, can I ask you more questions? He's required Mr. Pennington to be in the patrol car, where Mr. Pennington had said, I don't want to leave my own car, but he was in the patrol car. He does hand him back his documents, but he never says you're free to leave. He never says, can I ask you more questions? It's an accusatory tone. He's asking him, are you on probation or parole? Am I going to find anything illegal in the car? So, I mean, there's nothing about this encounter that changes it into a consensual encounter.
What do we do then if we take, I want to move quickly to the Ninth Circuit case that you've cited quite a bit, as far as once this has moved to Trooper Lillard stop, and how does the taint from, let's say there was a taint that once we asked, can I search your vehicle, that 4 to 5 minutes, how was there not, and I'm particularly focused on the continuation of what happened with Trooper Lillard, that those intervening circumstances kind of separates the taint, even if we accept that the first stop tainted the second?
So I know that there was the initial, Sergeant Lillard sees the traffic violation, and that fact is present in Gorman as well. So there was a traffic infraction there too. And the court in Gorman, which I think is persuasive and should apply here, said that this is all flowing again from that unreasonably prolonged stop. There would never have been a stop. There would never have been a dog sniff. And I think those same factors are present here. Sergeant Lillard's stop would never have come about. I think you could even say, clearly if Mr. Pennington had consented to the search, things would have been different, but he didn't consent to the search, and everything flows from that.
I'm sorry, I just want to double back on what you just said. If he had consented to the search, there's no problem.
No, sorry, there would have been a problem. The whole analysis would have been
okay.
different.
I thought you might want to amend that. Okay.
No, I just think the whole fact pattern changes at that point. If he had consented to the search, obviously there would have probably been a search. There probably would have been no second stop. But I think that would have been tainted by the unreasonably prolonged stop.
Let me follow up on that, because if he had consented to the search, right after Officer Flack gives him back his documents, ordinarily that means we're done. You're free to go. And then he asked for consent to search. Pennington says no. And he said, I'm not going to violate your rights or anything, but I've got some concerns here. And then continues the conversation with, the 4 minutes or whatever it was of additional questions. If he had given consent to search, that initial question asking for consent to search would not have prolonged the stop.
Well,
So he was free to leave at that point?
No, I think if he had consented, our argument would be that that was tainted by the fact that the stop was unreasonably prolonged, and that question
By the
came-
one question?
No, by the
Because
fact that
that's where I'm trying to pin this down. At what point was the stop unreasonably extended?
So the first stop, everything after the warning was issued. So that wasn't a consensual.
So even the request for consent to search was a Fourth Amendment violation in your view?
In this case, because it came after the point at which the warning had already been issued.
Well,
So-
that happens a lot of times. In Wisconsin, that's called a badger stop. They always ask after they give the warning. They say, by the way, do you have anything in the car that you shouldn't have? And that's been approved as not a violation of the Fourth Amendment. Now, that may be right or wrong, but I want to pin down what the position is. If everything after the documents are returned is a Fourth Amendment violation, even the first question, which occurs in the first 30 seconds, we need a justification for that position.
So I think Rodriguez is clear that once the warning has been issued, the mission of the stop has ended. So here I have to go back and see the exact order. I'd have to go back and check. I don't think the consent was necessarily the very first question. I mean, he asks him a number of questions for several minutes. And so, sure, if someone's going to leave and they're sort of leaving at the same time, someone says, hey, can I ask you a few more questions? That's a different fact pattern. But here we've got an officer who continues to ask, again, not just for consent. He asks about his parole status. Is this your car? I mean, he's continuing to interrogate him after the mission has ended. And I want
Ms.
to
Small,
answer as many
could I-
questions as you have. I do see my time's out.
But if I'd like to follow up on this a little bit, though, because it's obviously we're talking about daily practices by many police officers. And maybe I'm out of touch on this, but I thought most of the case law involving this idea, here's your license and here's the warning. Most of that case law, as I understand it, involves drivers who are still in their own cars.
I think, yes.
And that's why I asked you earlier about the fact that Pennington was in the police car when this happens. And I will want to ask counsel for the government about this, but I'm not sure I would feel at all comfortable just opening up the door of the police car and walking away without the officer explicitly telling me you're free to go now. And so that I don't know how broadly you need to cling to the idea that one question after delivery of documents is a violation of the Fourth Amendment.
Right. And again, I don't think the court needs to go that far here, given the facts of this case.
Well, it's an important question, though, because officers in the field need bright line rules about what they can and cannot do. And that's why I asked the question, to try to situate this within actual police practice for Fourth Amendment rules that courts hand down. And obviously, everything in the Fourth Amendment domain is fact-specific, but where possible, we try to be clear about what's permissible and what's impermissible. So we need to know what exactly the rule that you're proposing is.
So I think, again, the rule under Rodriguez is clear that once the warning has issued, there should be no further questioning of somebody who's detained. Again, I mean, if there are facts showing that they have been released, they're in their own car, they have their documents back, and it turns into a consensual encounter, officers can follow up with additional questioning.
Well,
But
it's always a detention, even if the driver is in his own car. And sometimes the driver is outside the car and they do the whole encounter outside the car. Sometimes the driver is in the squad car. Variations in the fact pattern, but it's all a detention. So your point about it depends on whether there was a detention. It's all a detention until it's not. And so what is that line, I guess, for lack of a better way to describe it, so that we can be clear about what we're saying is a constitutional violation if we side for you?
Yeah, and so I think in the cases where courts have said it converted to a consensual encounter, there were facts like the driver was in his own car, he got his documents back, the officer said you're free to leave, but can I ask you a few more questions? Facts like that. So I mean, in terms of a bright line rule, again, I think the most bright line of a rule that can be drawn here is Rodriguez's rule, which is that once the warning is issued, the mission for the stop has ended, and it shouldn't be prolonged to investigate other activity. And I think here there was a clear violation of that rule in the first stop. But I do also want to be clear that the court can also hold that the second stop was independently unreasonably prolonged and doesn't have to reach the issues with respect to the first stop.
Thank you.
So I know I'm out of time to the extent I have
I'll
any
give you
time.
extra time.
Okay, thank you. Thanks.
Mr. Keenstra. Good morning.
May it please the court. Good morning, Your Honors. Jeff Kinstra on behalf of the United States. The district court correctly rejected the various motions to suppress the evidence here. The second stop by Trooper Lillard that gave rise to the discovery of evidence was valid at its outset, and probable cause to conduct the search develops during the lawful duration of that search. The earlier stop by Trooper Flack was likewise reasonable in duration, and regardless, even if there were an alleged delay at the end of that stop, it would not have justified suppressing evidence discovered during the later stop by Trooper Lillard, as the district court found.
Is the government conceding then that Master Sergeant Fleck asked for consent to search after the first traffic stop was completed?
Well, so we do argue that once he handed the documents back, at that point the stop or the interaction became consensual.
Okay.
And so that is certainly one ground in which this court would
How,
resolve the case.
and how was Mr. Pennington supposed to know that he was free to go?
As courts have recognized, the act of handing the documents back, handing the warning back, conveys to the individual that the business of the traffic stop is done. To Your Honor's question about the officer saying something about you're free to leave or something like that, the officer never said anything like that during this encounter. The defendant got out of the car anyway. So even after the officer asked these questions,
Right, but how is a civilian supposed to know when he is free to leave a police car?
So that's a reasonable person standard based on the facts presented. And the courts have recognized that, again, typically handing documents back conveys that the stop is over, but that's not dispositive if there are other factors. Say, in one of this court's cases, the documents were returned, but the officer said at the same time, there's a dog on the way, which conveyed pretty clearly to the individual that he needed to remain on the scene. There is no countervailing circumstance of that sort here.
Why not just adopt a bright line rule that says when you're stopped by the police, you are detained until the officer says you are free to go?
Essentially because that wouldn't be consistent with the Supreme Court's precedent that it's an objective person standard. So that sort of magic words requirements wouldn't be consistent with Supreme Court precedent.
Well, this seems like having to read tea leaves for a civilian. Call it magic words, call it what you like, but we all know how fraught civilian police encounters and detentions and traffic stops can be.
And so really the question is whether the individual would have been free at that point to decline further questioning and terminate the encounter.
And open up the door and walk away, right?
Right, and the officer had conveyed to him under the premise that he had handed the documents back, handed all of his documents, handed the warning, that the officer's business was done.
Then why can't he just say that? I mean, frankly, what you're describing seems wildly unrealistic to me.
Well, what I'm describing is what the case law says. So I'm not making this up. It is an objective
I know you're not
person
making
standard.
this up, but I'm not sure how closely tied a lot of appellate courts are to the realities of those encounters.
Well, I think that also just recognizes how people interact. People, when they're having a face-to-face encounter, they have those cues.
You can
they
have
understand.
a cue. There can be nonverbal cues. I get that. But that's pretty tough to tell for a reviewing court from a video.
And that's fair as well. Now, even assuming that at that point of the encounter that the stop continued in progress, based on that assumption, the stop was not done because the defendant was still had to be
You mean the
allowed.
search?
I'm sorry.
You said the stop was not done?
Yeah, that's correct. The purpose of the stop and the stop itself was not done on that assumption because at least one step would have remained at that point, meaning allowing the defendant to return to his car, which of courts have recognized is a perilous point in an encounter for an officer. That's the reason that officers can remove individuals from their cars during a traffic stop, because they could have
Right.
weapons in the car. In Michigan versus Long, other decisions of this courts have recognized that there is a risk to the officer when an individual will be allowed to return to their car. And so the safety concern of the stop, which is a paramount concern at every point of every interaction, still remained in full force. And so even assuming that this was still a stop, the officer was justified based on the truly bizarre and extreme circumstances that were facing him by the defendant at that point to
What
make
were
the
they?
reasonable inquiries.
Bizarre and extreme.
What were the bizarre
It was
circumstances, other than him being nervous?
it was the defendant's extreme nervousness, not just nervousness. So the officer testified that the defendant was overly nervous at the outset, and then that progressed and escalated.
And he
throughout the
explained, I'm
stop.
overly nervous because it's my understanding that police kill black people.
That's what the defendant claimed. And the officer, of course, has over a decade of experience and testified this is the most extreme situation he had seen during his career. And so when faced with a situation where obviously the source of his nervousness was not traffic related, the officer was cordial throughout. So whatever was in that car, the officer had good reason to believe was having a profound effect on the defendant's behavior. It was causing a profound reaction by the defendant as he was sitting there. And so before allowing the defendant to return to his car, where that reaction could have produced unpredictable results, the defendant could have regained access to anything in the car, it's reasonable for the officer to have made the very limited inquiries that he made here. He asked 4 questions after the warning printed that took about 2.5 minutes. The questions were, you're pretty nervous, are you sure there's nothing in your car? With your nervousness, do you mind if I take a look through your car? And the defendant denied that anything was in his car, declined consent, and then went on his way. So none of that portion of the stop that the defendant is objecting to produced any new information. And that makes this a very different situation from Gorman, for example, where the stop detoured early on. The officer conducted irrelevant records checks about the defendant's residence. Those irrelevant checks produced entirely new information that the officers would not have otherwise had. Based on that new information, the officer then spent an additional 10 minutes questioning the defendant, obtaining further information, including that there was $2,000 at least inside the vehicle. The officer then conveyed all of that information to a second officer, along with an affirmative request that he conduct a stop. None of that is true here. The 3 or 4 questions that the officer asked at the end produced no new information at all. And the troopers' delayed stop an hour later was not motivated or affected in any way by this objective.
And I guess that's really the question where we have to get to is looking at that Ninth Circuit case, is the taint occurring after the written warning is issued? Is that what Mr. Pennington is suggesting? Is that the suspicion of Trooper Flack wasn't raised until Pennington refused to allow him to search? Or does the suspicion reach back while Trooper Flack is still preparing, Flack was still preparing the written warning?
Right. And so I think that is what the defendant's arguing. But as the record makes clear, and as the officer testified, his suspicions at that point and the defendant's...
At which point?
At the point that the warning had printed, and this is on page 12 of the transcript, he says that the defendant's, quote, extreme nervousness was the reason he asked those follow-up questions. And in fact, he prefaced each of his questions with references to the defendant's nervousness. He said, you're pretty nervous, do you mind if I take a look through your car? With your nervousness, or you're pretty nervous, are you sure there's nothing in there? With your nervousness, do you mind if I take a look through the car? When the defendant declined consent, his response was, well, I'm not going to violate your rights or anything. If you don't want me to search, I'm not going to search. But I believe you're up to something, you're pretty darn nervous. So the suspicions and the defendant's nervousness pre-existed this portion of the stop that the defendant is challenging. On top of that, the stop by Lillard took place over an hour later. During that time, the defendant was entirely at liberty. He was not under police surveillance. He could have stopped and disposed of the drugs if he wanted to.
Mr. Keenstra, suppose, well, let's take this a step at a time. Under Rodriguez, is an officer allowed to run through all the records checks twice in an ordinary traffic stop?
That wouldn't be routine for the same officer.
You'd have to have a
that.
good reason to do it, right?
Right, and this
Okay.
court has recognized, for example, with frisks, that
Right.
it's not
Now,
always
frisks are different, but we're talking about and I understand an
Well-
officer doesn't have to depend on his colleague's frisk of a suspect. But with respect to records checks, then suppose it's the same. It's two stops by the same officer an hour apart.
Sure.
Is the officer entitled to do the same checks all over again for license, registration, criminal history, and so on?
I think in that circumstance, it's a similar analysis because the officer actually has that information himself. He's done it, he's confirmed it. And importantly, the criminal history is very important because the criminal history is for the officer's safety. And that's where it becomes so important here that it was a separate officer at the second stop. Now,
Is there any doubt, though, that Lillard was briefed by Flack about this driver's criminal history?
Yes, as your honors have already recognized, Flack didn't even provide the name of the individual he had interacted with. He didn't say whether there were multiple individuals in the car. So Pennington didn't know who this individual was. He couldn't be sure it was the
You
same
mean
person.
Lillard, not Pennington?
I'm sorry, thank you, Your Honor. That's correct. Lillard. Now, so for that reason, it's reasonable for him to obtain the individual's driver's license and to confirm its validity. As to the criminal history, the only information that Flack had provided was very general information concerning only the suspicions of drug dealing or drug possession. He said the person has a history of trafficking cocaine and weed. He didn't say any details about those matters. He didn't say whether there were arrests or convictions. He didn't say when or where they occurred. On top of that, he didn't say or purport to say anything at all about whether the defendant had a history of violence or gang affiliation. And in fact, the defendant did have a prior battery conviction, at least 2 convictions for resisting police, and a prior gang affiliation. Those are all matters that are relevant to an officer to protect their own safety. Those are also matters that weren't conveyed to Lillard. And so for the very same reason that Flack, during the first stop, was entitled to ask the dispatcher to continue providing information about the defendant's criminal history, so was Lillard entitled to obtain that same information for himself for the same reason, so that each officer could protect their own safety.
Any reason to double-check registration and insurance?
The officer, in fact, did those things before the stop occurred.
Exactly, yeah.
Because he had the license plate. And so he didn't have to do those things after the stop. He didn't have to reduplicate those tasks. But he didn't know the license was valid. He didn't know the defendant's criminal history. And so he was entitled to run those checks for himself under these circumstances where it's a separate officer.
Does the record here suggest any reason to have Officer Dorsey issue the warning other than to free Lillard to do the dog sniff?
So the record doesn't say exactly why. The subjective reason, I suspect, was the dog sniff.
I'm asking for the record. I suspect so too, okay?
Right.
I don't see any other reason. I'm asking you, is there any other reason suggested by the record?
No.
Okay, thank you.
But to that issue, it's common ground, I take it, that the canine sniff itself had no effect on the stop's length. While Lillard was running the dog, Dorsey was in the car working on the warning. So what the defendant is objecting to then is really the officer's allocation of tasks at the earlier point of the stop where they switched places. And there's really no requirement under the First or the Fourth Amendment that officers take the fastest possible course, that they act in the most expeditious possible manner. They only have to act reasonably. And for that reason, courts don't second-guess their logistical decisions or the allocation of tasks, as this court's case law reflects. Here, there was a task that remained to be completed, namely the warning had to be written. There were 2 officers on the scene. One of them had to do it, and that's exactly what happened. Lillard asked Dorsey to write the warning. He took a spot and commenced writing the warning, and that didn't create, in fact, in the district court's findings, that caused no delay on the stop. But even if there were a de minimis delay, The de minimis length means that it's a reasonable one.
When did Trooper Dorsey arrive at the stop? Do we know?
We don't have it timestamped, but the testimony from both Dorsey and Lillard is that it was within a few minutes of when the stop occurred. He had alerted Dorsey even before he saw the defendant that he was going to be looking for him. Once he saw the defendant pass him, he sent Dorsey a message, and so Dorsey then responded to the scene and was on site within a matter of minutes. He was also there minutes before, at least, he was asked to take the place of Officer Lillard. So as your honors have recognized, this wasn't a sort of situation where the officers are delaying in hopes that they'll be able to conduct the canine search. So that both the canine, the backup officer were on site at the same time. So it was just a matter of allocating the tasks so that that could occur. I'm happy to answer any other questions, but I see my time is out, so we'd ask this court to affirm.
Thank you.
Thank you, your honors.
Ms. Small, your time had expired, but I'll give you some extra time in rebuttal.
Thank you, Your Honor. Just briefly, the court doesn't have to say, task allocation is not okay or calling backup is not okay. Those are things that officers can do, but they always have to remain reasonable. And here, in the context of this stop, given everything that had occurred, the first stop, which lasted 25 minutes, the 13 minutes of redundant records checks, the problems with his computer, which the officer, that wasn't his fault, but it still had already delayed the stop. The fact that he would then, instead of just going ahead and writing the warning, but that he would then call in another officer to the scene, spend the time waiting for the officer to arrive, spend the time debriefing him, spend the time switching places with him. It was 2 to 3 minutes of that, and that was unreasonable under these circumstances given the facts. And a reasonably diligent officer who wasn't trying to conduct a dog sniff would have just written the warning. That, I think, is a key point in this case, and a key moment in this case, is that handoff is really, I think, one of the clearest examples of why this stop was unreasonably prolonged. And I'll just end by saying pretextual stops are clearly okay under the law. That is something that Wren clearly allows. But the Supreme Court has also tried to impose meaningful limits by way of Rodriguez and other cases along those lines to say that stops cannot be prolonged beyond their mission. And when you have a case like this one where it's clear that there was pretext for the stop, I think courts there should be a heightened awareness for what the officers are doing, and there is a high risk that the officers are going to prolong the stop, and that is what happened here.
Ms. Small, could you comment briefly on the government's argument that Officer Lillard was entitled to do a new round of criminal history checks to get the full details?
So I think that I think the example of 2 officers on the scene at the same time is helpful here, because I think if you had one officer do a records check, and then you have a second officer say, well, I want to do my own records check because I want to feel comfortable, even though you just told me that everything checked out. I think that would be clear that that is unreasonable. And this case is really no different from that. You have these stops, they're technically 2 separate stops, but they happen within an hour. You have all of the information relayed. You even have Sergeant Lillard testifying, I had no concern. This isn't a situation where the officer testified, I don't trust those records checks, I wanted to do my own records checks. He didn't say any of that. He just said, this is just my process. But that, just because it's his process, it doesn't make it reasonable under the Fourth Amendment. Thank you.
Thank you. Our thanks to all counsel. We'll take the case under advisement. Ms. Small, you and your law firm, I believe, took this case pro bono by appointment of the court, so you have the thanks of the court for your service to your client and the court. Thank you. Our next case for argument is Stella Pateraklis, if I'm pronouncing that correctly, versus City of Chicago. for whenever you're ready.
May it please the court, my name is Heidi Carsleeper, and I represent the appellant in this matter, Stella Patarakos. This case is a fairly straightforward employment matter where the district court granted summary judgment and violated the adages that the courts are not supposed to take over the job of the jury by weighing conflicting evidence, resolving swearing contests, or determining credibility, or pondering which side's facts are the truth. In this case, we allege that the district court violated this principle in two ways. One, the district court made credibility determinations and weighed the evidence. And two, the district court erred in her analysis in going through the prima facie case and finding a failure in the prima facie case, where the recent case law of this circuit is that the district court analysis is supposed to skip the prima facie case when you're dealing with an issue of whether performance was raised as the reason for the adverse employment actions. In Viccio versus U.S. Foods, 88 F. 4th, 687, the Seventh Circuit held that when performance is raised as an issue, the district court does not need to consider the prima facie case of McDonnell Douglas. The reason for this is clear in this case. When you're looking at a situation where the people judging a plaintiff's performance are the same people that are being accused of discrimination, there are issues in determining whether the plaintiff's performance is meeting the legitimate expectations. Additionally, there are issues that arise in determining whether a comparator is truly a comparator when you have a plaintiff who is being targeted and disciplined disproportionately from those around her. The element of whether the plaintiff is meeting her legitimate expectations is not applicable in this type of situation where, like I said, where the people are judging the plaintiff's performance are also accused of discriminating against her.
Ms. Sleeper, in a discriminatory discipline case, at least as I understand the law, you still need comparators, right?
Comparators are one way that a plaintiff can show that there's an inference of discrimination.
If you're trying to make a circumstantial case
Yes.
based on discriminatory discipline, you've got to be able to show some other folks' disciplinary situations, right?
That is one of the ways that you can show it. I don't think that you have to show it. You can. There's also, if you look at Troop versus May, there's other ways that you can show an inference of discrimination other than just relying on similarly situated.
Yeah, okay, but you don't have any explicit evidence of racial bias here, and the theory of discriminatory discipline here, I don't see how it works without comparisons.
Right,
In this
and-
case,
Right,
We
and
can
we
have a
did. I'm sorry.
we can have a theoretical discussion about other cases, but this looks to me like you need good comparators.
Correct, and the plaintiff did set forth good comparators. In this case, the plaintiff pointed to other employees who had the same job title as her, had the same supervisor as her, and were not in the same racial class as her, that were treated differently. Now, the court held that
And who are those individuals?
we're talking about Barbara Anderson and Gregory Turner.
And is that referenced in the opening brief?
Yes.
Where?
So if we look at the one, I think I have the wrong one.
That's the reply.
Yeah, sorry. Plaintiff set forth the comparators in the summary of the argument, statement of the facts area. And also in her argument, at page nine in the opening brief.
On page 9,
Yes,
in the statement of facts.
yes, we set forth the factual circumstances that she was treated differently than her non-white coworkers.
And on page 9, she identifies Anderson and Turner as two African Americans who reported to Crystal Warren.
Yes.
And the question where I was going is, where has she identified those two individuals as comparators to the conduct that she engaged in? She did identify those as two African Americans that also reported to Crystal Warren.
Right, and that is the whole basis of her argument, is that she was treated differently than those non-white coworkers set forth.
Because
I addressed this in the reply.
there's a substantial amount of conversation in the response that these arguments are now waived because you bring them up for the first time in the reply. So that's why I just wanted to spend a moment, but go ahead.
Sure. So, and I did mention in the reply where we brought it up. Regarding the comparators, the district court found that the comparators were not similarly situated because they had not suffered the same discipline that the plaintiff did. And that's where this issue of going through the prima facie case, when you're looking at a disparate discipline issue, falters regarding looking at the comparators. Ms. Paterakis'
But
disciplinary...
Moran kind of gives us a little bit of trouble if we want to walk back from the McDonald test, and that's the way the evidence was presented before the district court.
Right. At the defendants, when they filed summary judgment, went through the McDonnell-Douglas steps. Plaintiff responded to those steps. Now, the court's analysis, though, I believe, is improper under Coleman, looking at the comparators and requiring the comparators to have the exact same discipline as the plaintiff, when the plaintiff is complaining that that discipline is being meted out disproportionately. That's exactly why this argument fails, is because you're never going to have a comparator that has the exact same discipline when that's the point. They're not being disciplined as
I don't think that was the district court's thinking. I thought her thinking was you hadn't shown evidence that black employees had engaged in misconduct, just broadly speaking, on a scale comparable to what Paterakis had done.
right, and that's the point. Warren and Pulfas both stated that they were monitoring Paterakis, nobody else. So they're not going to have the scale of discipline that Paterakis did when she's the only one that's being singled out. She's the only one that's being monitored for those disciplines. We set forth in our brief and in the summary judgment all of the areas where Anderson and Turner were performing at the same level as the plaintiff when it came to issues as, you know, putting their phones on hold or going on breaks. And, you know, I think our argument is that under Coleman, the district court put too much of a rigid standard in these comparators. In Coleman, the court sets forth, you know, you have to look for comparators, not clones. You're not going to have, you know, somebody that is exactly one for one as a comparator when you're talking about disparate discipline. I also want to touch on the credibility issue.
Aside from the phone issue in regards to that first suspension, she was also suspended for violating 2 additional policies, and that was the lunch policy and the misusing of office equipment. And so I want to make sure Anderson and Turner, neither one of those individuals were disciplined for those violations. Is that correct?
That's correct.
Okay.
There was testimony from Ms. Paterakos and also from the union that there is no policy regarding using office equipment and that people did it all the time and nobody had ever been disciplined for it. So while specifically addressing Anderson and Turner's use of it, we can still show that plaintiff was the only one who was ever disciplined for this, even though there's testimony from the union representative and Ms. Paterakos that this happened all the time, and that there was no policy that existed that she couldn't use it.
In regards to the second suspension in the webinar, was there any comparator that also did not attend?
There was one other employee who did not attend. The situation is slightly different. I think on that point, the main point on how that was pretextual that the plaintiff points out is that
I want to go back to a comparator. Do we have a comparator for the second suspension? I didn't see anything in the evidence to demonstrate whether or not Madison attended or did not attend.
Madison did not attend, as well as there was one other employee who, I'm blanking on his name at the moment, I apologize, an African-American employee, Creshawn Burt, I believe, who said, I'm not using my own equipment to participate in work. So he ended up taking vacation days that whole time. So he would not have attended that as well.
And I didn't see any citation to the record, though. I know you're representing to us that Madison did not attend. I didn't see anything in the record that supported that. Did I miss it?
It should be in the statement of facts that Holfus allowed her to not attend because she was out of town or something that day.
Madison was actually ordered to attend. I think you might be confusing the comparators.
Okay.
And so in the statement of facts, I did not see a reference answering even though she was ordered to attend by Warren, whether or not she attended. I'm just trying to identify a comparator.
Sure. I don't believe that she attended. I don't recall.
Okay, that's fine. And
Exactly.
as to the third suspension?
The third suspension deals with
The intermittent FMLA? Is there
Yes.
a comparator there?
So there's nobody else in the department that specifically was on FMLA to compare with that. The issue with that third suspension, again, looking at the pretext of it and whether there is an actual factual basis for the suspension, we show that there was no policy that said that people couldn't talk to the police officers in the lobby, that all of the other employees were allowed to do that. Other employees were allowed to be in the office on their breaks without question, whereas Ms. Paterakos was not. Defendants make a lot about Beverly Anderson not leaving the room during her lunch breaks or during her 15-minute breaks, but that was an area where Ms. Paterakos was actually criticized and told she could not stay in the office. So she's being treated differently in where she can be, who she can talk to, and they're disciplining her for policies that don't exist, and they know they don't exist. There's an email from Monica Raffick to Crystal Warren saying, don't email her. We don't know whether we can actually require her to not be here. So they know that there's no policy that says she can't do that, and yet they're still disciplining her. I want to. My time is up, but if you have any more questions, I can go through it.
Thank you.
Thank you.
Ms. Masters.
May it please the court, Ruth Masters on behalf of the city. Ms. Paterakos is an employee who repeatedly failed to follow the rules and now alleges that her resulting discipline violates Title VII's prohibition against racial discrimination and the FMLA's prohibition against retaliation and interference. This morning I'm going to discuss the lack of evidence showing a genuine issue of material fact on the merits of any of her allegations, but I am going to begin with waiver. And the place I want to start is, in this case, the plaintiff briefed and argued the prima facie case. She did not say to the district court, you don't have to consider the prima facie case, don't rule on the prima facie case. She briefed and argued it. You'll find it in the response to summary judgment, which is docket number 126. And she lost. And she lost on the prima facie case on someone who is similarly situated. The Moran case, Moran versus Advocate Christ Hospital, is directly on point to that. You can't come up on appeal and argue that there is error when the district court applies the test that you told them to apply. And that's what's happening here. That in and of itself is a basis for affirming, because she's not, and then the other questions, I think Judge Pryor, you asked, is that there's an argument on this in her argument section about anyone who is similarly situated. So she loses on that and then comes up on appeal, doesn't argue it, and is referring to various places maybe in her statement of facts, but that doesn't even clearly identify Gregory Turner and Beverly Anderson, who she is now referring to. The argument, I think, it's just not in there, and I commend that to you.
On the second suspension, what about Mary Ann Madison?
So, with respect to counsel, I believe that there was some confusion about who didn't attend. Mary Ann Anderson was ordered to attend. There's no evidence she didn't attend, and she is a comparator. The plaintiff doesn't consider her a comparator, but she is a comparator. She's the only other person in the same situation who was at work that day, who was told to attend. She's black, and there's no evidence in the lease that she didn't attend. And so there's no evidence of discrimination on that. On the first suspension, there's no evidence on any of these that anybody else behaved the same as Ms. Paterakos, and there's no evidence, there's no comparator on lunch. She's told, and first of all, that is the rule. There's no dispute that is the rule, that everybody is supposed to go to lunch at their assigned lunchtime, and she's the only one who doesn't. There's no one who doesn't, any record of anybody else who does not do that. And not only does she not go to lunch on her assigned time, the first day that Ms. Warren is in room 20, in the room, which is March 20th, she sees Ms. Paterakos in the hall at 2 o'clock, and they have a conversation. You need to take your lunch at your lunch hour. On March 25th, they have a conversation with her. You have to take lunch at your lunch hour. On March 26th, the next day, Ms. Paterakos goes to lunch, not at 1 o'clock when her lunchtime is, but at 1:20. So she goes 20 minutes late the next day. On April 1st, there's another conversation with her. Go to lunch on your lunchtime, which had switched to being noon by that point. On April 3rd, she leaves the building at 1:23. So she leaves the building an hour, 23 minutes after her lunch, and she comes back at 2:35. So more than an hour she's taken for lunch. There's absolutely no comparator on that. There's no comparator on putting your phone in not ready status. that she is doing it more than anybody else. Everybody else is told to do it. There's no comparators on that. Regarding the fax machine, the specific complaint against her is not only is she using the fax machine, she's using it to accept samples of 8 pharmaceutical samples delivered. And so they think she's running a business. So it's not just the use of the fax machine, it's running a business. No comparator on that as well. Regarding FMLA leave, she is on leave. She is seen socializing. There's no dispute that she's socializing. She returns late from FMLA leave. She's charged with violating or abusing her FMLA leave for 4 different days. On those 4 different days, she is in front of City Hall during her leave, and yet she returns late 15 to 24 minutes each of those days. And again, they can see her out there socializing. There's no basis to think that the discipline of her is based on discriminatory animus, as opposed to the fact that she is violating the rules in front of everybody.
Ms. Masters, there apparently are some discrepancies between phone records and the specific accusations regarding abuse of FMLA leave. Could you address those?
I will, because at most that's not showing she isn't on the phone. The actual phone records, which are in discovery, showed that she is on the phone. And when you, if you turn to the disciplinary charge themselves, the pre-disciplinary notice and then the actual disciplinary notice, because there's 2 phases, most of the entries on the phone, it'll say on the phone and or socializing. So they're not locked into specific phone times. And she is on the phone. And that and the socializing, frankly, the socializing alone is enough to have given her supervisors an honest suspicion, and that's all they need, is a reasonably held honest suspicion that she is abusing FMLA time. And there's no reason, there's undisputed facts that support that finding. And for that reason as well, her FMLA claims fail, because both interference and retaliation fail if there's an honestly held suspicion that someone is violating FMLA. If the court has no questions, we would stand on the brief and ask that the judgment of the district court be affirmed.
Thank you.
Thank you.
Ms. Sleeper, you had used all your time, but I'll give you an extra minute in rebuttal if you have something else to say.
I just want to address a couple of points really quickly. One regarding argument on summary judgment and a waiver. Plaintiff argued on page 13 of her summary judgment response that the element of meeting an employer's legitimate expectations was not applicable in this situation where plaintiff's performance was being judged by the people she was accusing were discriminating against her. So the same argument was made at the district court level as is being made here today. Additionally, regarding the lunchtime comparators, Beverly Anderson did testify that she had no issues with if she took 15 minutes over her lunchtime on a call, that she could go to lunch later. That was the same behavior that plaintiff was engaged in. So she is a comparator on that issue. The issue of plaintiff running a second business as part of the discipline over the fax machine, that goes to show that there was no factual basis for the disciplines that plaintiff was receiving. That was one of the things that we pointed out, was that there was no second business. She ordered some vitamins for her parents because that's who she was taking care of for her FMLA leave. So the accusation that she was running some second business, there was no factual basis for that. Regarding plaintiff returning late, we don't dispute that, that she was not a perfect employee. Perez versus Thornton's Incorporated, all employees, not perfect employees, are protected by Title VII. So we've never argued that, just that coming back late from lunch or clocking in late that is not, could not be appropriate discipline.
But
That's-
doesn't that collapse your entire argument, reliance on Viaco?
I'm sorry.
Viaco versus US Foods.
Yes,
Your whole argument is that once the employer raises performance as the issue, we can skip and move directly to, we don't need comparators, we can move directly to pretext. But in that case in particular, the Viaco had presented sufficient evidence to rebut USS Foods' assertion that plaintiff's performance was poor. If you accept that your client's performance was poor, if you accept that she was violating these policies, no, that's not what you
no,
accept.
no, I'm saying on the very discrete issue of, did she come back late from FMLA a time or two? Did she log in late? I'm saying that while the vast majority of the discipline that has led to these suspensions, she has directly refuted as not factual. I am not disputing that she may have come in late or clocked in late, but that, I think on that discrete issue, is different than just saying she's a poor performer and none, you know, and all of this discipline is warranted. That's not what I'm arguing.
All right, you'll have to wrap up your time.
Yeah,
It's long
and then
since
I just wanted to say on the honest suspicion, regarding the FMLA, Warren testified specifically that she didn't know whether a plaintiff was violating the FMLA, and that was above her pay grade. So I believe that there was no honest suspicion. She just was going to discipline her no matter what. And again, that was part of the credibility determinations that the district court erred in making, was looking at the pretext and making it a subjective standard as to whether Warren believed she should be, her discipline was appropriate or not. Thank you.
Thank you. Our thanks to all counsel. We'll take the case under advisement. Our third case this morning is submitted on the briefs, so we will move to our fourth case, Whitaker versus Dempsey. Mr. Kelleher, good morning.
Good morning, Your Honors. Christopher Kelleher for the appellant. The district court in this case admitted that this matter turns on a credibility dispute. Yet the court decided it could decipher who was being more truthful. With due respect to the district court, this approach strikes at the heart of Rule 56 and hijacks the fact-finding process. We thus ask that a jury resolve this credibility clash. Can a he said, she said dispute be resolved at summary judgment? It can, but that's the exception, not the rule. And there's nothing to suggest that this case fits that rare paradigm.
Well, actually, this is a he said, they said.
True. That is true.
It's his version of events, which has shifted significantly over the course of the litigation, and he's been kind of all over the map on all kinds of key issues, issues key to his claim. And the defendants have been consistent and unified in their responses that it didn't happen the way he said it happened.
Certainly.
In
Your Honor.
either instance.
My position or my case would be easier if Mr. Whitaker had been consistent. However, if I can point out a few things which underlie this inconsistency, and one is obviously his mental state. I don't think there's any dispute that there are some mental issues here. Obviously, he's in the crisis wing of a state prison. The degree of his mental issues obviously might be disputed, but so I think to your question, I think part of the inconsistency is due to his mental instability. Obviously, he was pro se initially when he filed his first two complaints, and then obviously counsel was appointed, and that changed the dynamics a little bit. So there's that as well. Going to the actual inconsistencies, I would argue that they're more peripheral, at least as far as the cutting object itself. There's issues as to, well, if it was 1 inch versus 2 inches, something regarding those dimensions. And ultimately, I don't think that matters in the grand scheme of things because of the damage that this cutting object that we allege he had did. So again, there are some inconsistencies here. I would agree with that, but I also think that we have to view the facts from the purview of Mr. Whitaker, and that's
where we're kind of looking at that deposition. What are the facts from Mr. Whitaker as to? I guess we'll take each officer if that's okay, particularly Officer Dempsey. If we start with him in the 5 minutes.
Yes, Judge Pryor. As we, or I should say, as Mr. Whitaker testifies, he warned Officer Dempsey that he had an object. He said he was going to self-harm himself. He wanted help. He wanted counseling. And taking all that as true, it's what what Officer Dempsey did and said and also did not do. And the fact that Officer Dempsey, again, as we view the facts from the perspective of Mr. Whitaker, Officer Dempsey, again, I'll keep this family friendly, F off. I don't give a S. I don't care. It's those responses that lay the groundwork for a deliberate indifference claim. And then in addition, obviously, the waiting for 5 minutes, as we allege, that's another factor. That's, I would say, another layer of deliberate indifference. A third layer of deliberate indifference would be the fact that he doesn't do anything with regards to getting counseling, at least not initially or not quickly. So there's what I think makes this case somewhat unique from the deliberate indifference perspective is that we have, again, these multiple layers. What Officer Dempsey says, what he does, which is basically nothing, what he doesn't do.
Is Mr. Whitaker representing that during those 5 minutes, Officer Dempsey is watching Mr. Whitaker?
The short answer would be yes. The little bit, if I can elaborate a little bit, it's not entirely clear from the deposition testimony. And again, in this case, we're kind of hindered in that we only have one deposition, and that's obviously from the plaintiff's deposition. Why that's so, I'm not, obviously can't speak to that, but as I read the deposition testimony, it's that he essentially was standing there.
So if he's standing there for those 5 minutes watching Mr. Whitaker, because this goes to the judge's reasoning that the inconsistencies make it implausible. If he's standing there for the 5 minutes watching Mr. Whitaker, Officer Dempsey then would have seen Mr. Whitaker with the sharp object, place it in the vent.
Judge Pryor, that's a good question. I'm not sure because he could have done the cutting and then put it in the vent prior to Officer Dempsey being there. And that's again, and I'm not trying to evade Your Honor's question.
It's fine.
It's just that
that's the reason why both of those things can't be true. Either Officer Dempsey had to be there for the entirety of a 5 minute, as
right.
Mr. Whitaker represented, or at some point, Officer Dempsey could not have been there because Mr. Whitaker says he saw me, I showed the object, and he just stood there.
Right. And I understand that that
And that's
gap.
where the district court kind of went, is that looking at that Supreme Court case is that one of these things can't be true.
Certainly. And again, I would go back to the fact that we only have that one deposition. We do have some records, some prison records, but they're not, they don't
Right.
clarify much. But, and the other issue is obviously, you know, when someone, again, going back to the mental state, number one, and number two, the bleeding out, it's not entirely clear, maybe, you know, that Officer Dempsey left for a minute and then, but again, as far as the cutting object goes, the placement of it, as I stand here, I don't have a good answer to that just because of the record and again, all these uncertainties of this case. And, you know, if I can turn that into a positive for Mr. Whitaker, it would be that that's something that, again, you know, it's almost like we're having a dialogue about, these are more fact questions and credibility questions and the credibility of Mr. Whitaker. And I fully concede that Mr. Whitaker has some credibility issues.
But it's not the credibility, it's whether or not he has raised a fact issue. And that's where I'm really trying to parse this for Dempsey and going, I guess we should move to the excessive force as well.
Sure. And on the excessive force, again, that, as we point out in the briefs, Mr. Whitaker's handcuffed, he's on the ground, he's obviously bleeding out. There's some, again, some uncertainty as to whether he's passed out or not. I'm not entirely clear, even as I stand here now, whether he was unconscious for a short time or a long time. So that context, the issue is obviously, is Mr. Whitaker a threat, whether to the medical staff, officers, et cetera. And our position is he could not be a threat to anyone, given that context and given being handcuffed and on the ground and bleeding out and all those things.
Handcuffed and on the ground does not mean compliant. And he can still be thrashing around, right?
Certainly.
I guess my concern, Mr. Kelleher, is, you know, we have, I certainly understand your general point about summary judgment, but we also have, for example, the sham affidavit rule. We have other lines of cases where, in extreme cases, a district court can take such fact issues away. And I'm
Certainly, Your Honor. And if I can point out, obviously, Your Honor's just heard an employment discrimination case. If I can make an analogy to that or breach of contract cases where there's often a you know, he said, she said dispute, but in those realms, there's at least a history of shared interests. The employee worked for the employer, the two parties contracted. Here, obviously, we're dealing with an inmate guard scenario. This is a notoriously divisive relationship. Violence always looms. So what we have here is a different context. And again, I'm not saying that the officers are lying, but there's definitely there's definitely an issue of division, of divisiveness between these two camps, so to speak, and that's just a reality of peniological life. But so again, I recognize, Judge Hamilton, that there are some mechanisms that the court have to deal with these types of situations. But again, we're dealing with the situation where we have two sides that really are diametrically opposed to one another and don't trust each other. So nothing further. Thank you, Your Honors.
Ms. Hanson.
May it please the court, counsel, I'm Assistant Attorney General Christina Hansen on behalf of defendants appellees. The district court correctly applied the summary judgment standard and concluded that no reasonable jury could find on this record that Dempsey or Castaneda was deliberately indifferent to a serious risk that he would seriously harm himself, or that Bull's use of a single burst of pepper spray during the August 9 incident constituted excessive force. At this stage, the evidence must be viewed in the light most favorable to Whitaker, but the court does not adopt a version of facts that is so blatantly contradicted by the record that no reasonable jury could believe it. It is the plaintiff's burden at summary judgment to come forward with evidence and create a genuine triable issue of material fact. And plaintiff failed to meet his burden here. Whitaker's only evidence at trial, his deposition testimony, was contradicted by the evidence as well as was internally inconsistent and presented an implausible version of events. Starting with the August 9 incident, the evidence did not give rise to a reasonable inference that Dempsey was aware of but failed to take reasonable steps to protect him from an imminent risk of serious self-harm. The undisputed evidence was that Dempsey checked Whitaker's cell during his 9 p.m. Walk through the wing. Whitaker self-harmed, and within minutes, by Whitaker's own testimony, when he saw that Whitaker was bleeding, he contacted his supervisor for help. He contacted Bull. And that was the only step that Dempsey was authorized to take. The undisputed evidence in the record was that he wasn't permitted to enter a cell and do anything until he had contacted a supervisor and gotten backup. Whitaker's testimony that he displayed a piece of sharp metal when Dempsey allegedly refused to call a crisis counselor does not create a triable issue of fact because it's contradicted by his own prior statements. The incident report from the night of the incident, he self-reported that he had cut himself with a fingernail. He had an existing wound there, and he had reopened it with his fingernail. Whitaker's own testimony about the sharp incident simply didn't add up. It was contradicted by his own statements about the object. That first he had the object and he hit it, and then that he had he just had two different objects in the two incidents, and so his story just simply didn't add up. And beyond that, Dempsey took reasonable steps when he appreciated the risk of harm, as Whitaker's own testimony was that as soon as he saw that, or when he saw that he had been there the entire time, and when he saw that Whitaker was bleeding, he took the only step that was available to him, which was to call for backup, and assistance arrived, and they were able to tend to his cut, and he eventually was taken to the hospital. And so Dempsey did obtain help when he appreciated a risk of harm.
Ms. Hanson, obviously we're kind of out on the edge of summary judgment here. And we don't expect all witnesses to be perfectly consistent from one statement to another. I guess it's helpful to me if you focus on the internal contradictions between plaintiff's different statements and impossibilities within his own statements, so that if we were to affirm, we would not wind up taking a wrecking ball to the summary judgment jurisprudence.
Are you asking me why?
I'm asking you to focus not necessarily on what the defendants have said, but on the different versions plaintiff has provided and the internal contradictions within them. Does that give us a sufficient basis for affirming summary judgment without destroying limitations on and guardrails on summary judgment?
It does, Your Honor, because even if we put aside Dempsey's testimony, as the district court did put aside Dempsey's testimony and concluded that Whitaker's account of events just simply didn't add up, just simply did not create a triable issue of fact. First, there was no, his testimony that he displayed a metal object and threatened to cut himself was internally inconsistent because like I mentioned, the incident report from the incident, he reported at the time, contemporaneous with the incident, that he used his fingernail to cut himself. Additionally, he was unclear about the object. In his, again, at the time of the incident, he didn't mention having an object. In his complaint, he talked about having a metal object, and he described the size of it, and but no metal object was found in his cell. The undisputed testimony is that after the incident, prison staff searched his cell and was unable to locate any object. And then also his own statements were inconsistent with respect, again, to what the metal object was. He had, in his complaint, in his amended complaint that he filed with counsel, he described having two separate metal pieces, one on the 9th and a different one on the 16th. And then in his deposition testimony, he testified that he had a metal object that was hidden in the vent, that's what he used to cut himself on the 9th. And sometime before he was taken out of his cell, he hid that instrument in the vent. And again, that's internally inconsistent with his own testimony. Again, that he asked Dempsey for help, that Dempsey was at his cell when he asked for help, or when he asked to see a mental health professional, displayed the metal object, cut himself, and then went back and hid it in the cell's vent so that he could use it again on the 16th. And so,
Didn't he also tell the hospital medical personnel that he used a pen?
He did. He also told a different story to the incident report reported the fingernail, and then the hospital records indicated that he had reported at the hospital that he used a pen. And so, based on his sort of changing narrative, no reasonable jury could find that Dempsey was aware of but disregarded a substantial risk.
What about the August 16th incident? Any inconsistencies there? Or are we more focused on injury?
Well, in the August 16th injury would fail. The August 16th incident fails at the outset because he doesn't establish an objectively serious risk of harm. He didn't sustain a serious injury in that incident. By his own account, it was a cut. He did not seek, or he declined medical assistance for the cut. A nurse indicated that she was able to clean it, and then he declined medical assistance. He didn't go to the hospital for that incident. There wasn't significant bleeding. He simply didn't have an objectively serious injury on that occasion. He argued at summary judgment that he was a suicide risk, but even that was belied by the records because the contemporaneous reports, he didn't indicate that he was suicidal, and he certainly didn't testify that he told Castanado that he was suicidal. And so,
Say it one more time.
he didn't indicate in the contemporaneous reports, the medical reports at the time, he did not indicate that he was suicidal the day of the incident as well as the day following the incident. He said that he cut himself because he was concerned about court. He never indicated that he was suicidal, and there's no evidence that he told Castanado or that Castanado would have been aware that he was suicidal. And so for those reasons, the August 16th incident also does not create a triable issue of fact on deliberate indifference.
In the few minutes we have, let's move to the excessive force.
Okay.
That's the one that gets me a little somewhat concerned based on the judge's reasoning that, and I highlighted it here, he could have reasonably misconstrued, Lieutenant Boyle could have reasonably misconstrued plaintiff's actions and believed, if it turned out to be incorrect, that plaintiff was acting aggressively. How is that not weighing the evidence?
Because the district court we could disregard by Whitaker's own testimony, he was moving his arms. He testified in his deposition that he moved and the blood sprayed. And so on an excessive force claim, we look at the prison official's state of mind because they're making the quick decision on whether force is needed. And here, the force wasn't applied sadistically or maliciously, but to restore order. And I would note that he used a single burst of pepper spray. It didn't cause any long-term injury to Whitaker, and it was used for the purpose of restoring order. There's no dispute that blood splayed and that he moved his arms.
But there is no order. Mr. Whitaker did not testify that I was ordered to stop moving. Mr. Whitaker testified that the nurse was trying to bandage me, and I moved, blood splattered, and I was pepper sprayed. And the follow-up question was, did Lieutenant Boyle ask you anything? No. Did he give you any orders? No.
He was moving his arms when they were trying to bandage him up, and he was spilling blood, which was causing a health risk to the prison staff that were trying to attend to his wound. And so the spray was simply to ensure his compliance. And then he was immediately, I would add, as soon as his wound was attended to, he was taken to the wash station to rinse off. So there was no evidence. Whitaker simply pointed to no evidence that Bull acted maliciously or with some other intent other than to ensure compliance and to ensure the safety of the prison staff attending to his wound. And so for those reasons, we ask that you affirm. Thank you.
Thank you. Mr. Kelleher, I think you had used all your time, but I'll give you some extra time in rebuttal if you have something to say by way of response.
Thank you, Judge Sykes. As to the credibility issues, what makes this case unique is the fact that there's no extrinsic evidence, no video, no audio, no documentary evidence which belies what Mr. Whitaker had said. In other words, it's Mr. Whitaker himself, for better or for worse, that has created this credibility question. And on that point, again, I would argue that a lot of this concerns trivialities, like the size of the cutting object, but more importantly, again, it's that context. We're dealing with a gentleman who, by all counts, irrefutable, has mental issues, and then the context of the jail and the context of bleeding out, a suicide attempt, or at least a self-maiming attempt. So this is a different context from, I would say, your typical, let's say, corporate setting or even a traffic arrest. This was a much more extreme and stressful environment where he's bleeding out. As to the excessive force, Judge Pryor, you hit the nail on the head. There's
Thank
a definite. You're welcome. There's a definite credibility clash here. And again, that can't be resolved at summary judgment. So I appreciate the court's time.
Thank you very much. We'll take the case under advisement. Mr. Kelleher, I wasn't exactly sure, but I thought that you and your co-counsel below had been appointed by the district court. You took it over on appeal?
Your Honor, I would describe this as a self-appointed case.
Okay. Well, thank you for stepping in for your client and to replace the appointed counsel in the district court. Thank you. We'll move to our next case this morning. United States versus John Tavis Matlock. Ms. Christensen.
Good morning, Your Honors. May it please the court, counsel. My name is Joanna Christensen. I represent the appellant, John Tavis Matlock. What we have in this case are two addicts who are friends, who use half a gram of heroin together and go on their separate ways. Mr. Matlock went into his home. Miss Wiley drove home approximately 30 minutes, 24 minutes to her home. When she arrived home, her mother said she wasn't fully high. She went into her room where she was surrounded by other controlled substances. The government failed to prove beyond a reasonable doubt that Mr. Matlock's heroin was the but-for cause of Wiley's harm on December 11th, 2020. The court should vacate the statutory enhancement, which would, of course, result in a full resentencing. The Supreme Court in Burrage, I'm unsure how to say that, I've heard different, has required the but-for causation. The harm must result from the defendant's drugs. It can't just contribute to. The drugs just can't contribute to the victim's harm. It has to be a resulting harm. The harm Wiley suffered on December 11th would have occurred absent Mr. Matlock's drugs. She had multiple suppliers, as was established in the record, but most importantly, she was surrounded in her room with 6 different types of controlled substances. 4 of them marijuana or synthetic marijuana. 1 had black substance on it. She had a marijuana grinder in her hand when she was found. She had foil next to her when she was found. And there were also 2 bundles of heroin. The part of the issue in this case is that neither Wiley nor any of these substances were tested by law enforcement. And there is reasonable doubt where this set of circumstances occurred.
As I understand it, Ms. Christensen, there's no affirmative evidence of any other source of drugs that Wiley used that night, right?
That night specifically, no. What we have is basically her interactions with Mr. Matlock on that day, except for Mr. Britton.
And I guess one of the things, I'd like you to focus, if you could, on the text that that Wiley sent to Matlock after she got back from the hospital, that I only did what you saw me do. In the trial, was there any hearsay objection? Was there any limiting instruction given about that text?
No, not to my recollection. And I think that the argument is that that's what she texted. She also told the EMTs and the officers she hadn't used any, that she had done none that day.
Well, we know that's not true. So.
Right. I think addicts lie. I think that's a pretty reasonable understanding, is that she would have told him, I only use what you use, hey, be careful. I'm not sure she would have admitted that she used something else, or if she would have remembered that she used something else. I think that she was inconsistent with her admissions, both to him. She also texted Joshua Britton at the same time, she had been to his house. He testified she just got money from him. But I think that there is enough in here to have reasonable doubt regarding the substances that she used. And probably most importantly is this failure to investigate what else was around her. This court has found in other cases that when it's more than one potential source, unfortunately all 3 cases I cite to are Anderson cases. 2 of them are Monte Anderson, 1 is Turia Anderson, but the Monte Anderson, there were 2 separate sources of supply there, and he used both, and the court said that was not enough to show for the enhancement. The other case is the Krieger case, of course, when there was a fentanyl patch, but also around the victim there were other controlled substances, there was a syringe, and none of that had been tested. We're certainly not arguing, as the government says, that you can't obtain a conviction from results from unless you have toxicology testing. That's not what we're arguing. But in this case, when there is a plethora of drugs around someone when she overdoses, it's a necessary step for to go beyond a reasonable doubt.
Should we give any significance at all to the marijuana evidence here? I mean,
Well, I think some. I think more significant are the 2 other bundles of heroin that the officer identified on the video, the body cam. Because she was revived by Narcan, it was clearly an opioid-related overdose.
Yeah. Right.
It wouldn't be, she wouldn't have been revived if it had been something else. The concern about the marijuana is that some of the marijuana had a black substance on it, and as I cited in my brief, marijuana can be tainted. There was testimony that they hadn't seen that in the Kentucky county where this was investigated, but it is a possibility. The other concern about the marijuana is the synthetic marijuana, which is often, as this court is probably aware, tainted. Often contains items that have nothing to do with marijuana at all. So I think that the 2 bundles of heroin are probably the most significant. The marijuana has less significance. The gabapentin is also a significant factor.
Well, on that point, that's a prescription drug for her, right?
Yes, yes.
And at least as I understand the law, please tell me if you disagree, but if somebody takes an illegal opiate, and that winds up having some kind of interaction with prescription or other drugs, that still permits the inference of causation from the illegal drug. I mean, her prescription drugs weren't killing her, so.
Right, well, it probably depends on how much she took, honestly, but we don't know. Yes, if it had been just Mr. Matlock's heroin and the gabapentin, then that's essentially the contributing factor, but it's not but it's the results from it. It's not just a contributing factor. But when we have all the other evidence, I think gabapentin, again, on my hierarchy is fairly low, although it can interact. Depends on how much. If she would have overdosed just on Mr. Matlock's, then the gabapentin doesn't matter. But if Mr. Matlock's heroin was just a contributing factor to her overdose, that's not enough in the Supreme Court jurisprudence on the issue.
Because we're here on this Rule 29 motion for judgment of acquittal, I'm somewhat concerned, going back to Judge Hamilton's first question, if the text messages get in.
If they get in.
Yeah, once the text messages are in, where the statements in particular don't overdo it. And text message from her saying, I only use what you saw me use. And then him encouraging her, hey, then this stuff might not be for that line of text messages. Looking at it from a point of, is there enough that but for whatever Mr. Matlock provided on that date, she would not have overdosed. It just becomes somewhat unbalanced when you have the text messages alongside, of course, as you mentioned, the other drugs that were present.
I think the text messages only get us so far.
Okay.
And it's because she was inconsistent. He also, in general, they were friends. They knew each other, they used together. So when he says this stuff's not for you, it doesn't necessarily mean the stuff we used. I think in general, because then they go on to talk about how in 2021 it's going to be our year, we're going to stop using. And I think that when she's telling him I just did this, he doesn't know about everything else. And he's like, you have to be careful. And I think that goes more to the proof that he distributed to her, of course, which we've admitted, but not necessarily the proof that that caused her harm. So I see that I'm in my rebuttal time. I did want to address very quickly the sentencing. If this court finds that B1C does not apply, then resentencing has to occur regardless of whether Mr. Matlock raised that issue. Thank you.
Thank you. Mr. Oliver.
Good morning, Your Honors, and may it please the Court. Jordan Oliver here on behalf of the United States. We are asking that you affirm Mr. Matlock's conviction because the evidence presented during the 5-day trial that included over 150 exhibits and 20 witnesses was sufficient to convict him, which is the sole issue in this appeal. Because Mr. Matlock admitted to distributing heroin to Miss Wiley about an hour before her overdose, opposing counsel's challenges to the evidence, I would say, fall primarily into two buckets. First, the bucket relating to evidence supporting that heroin caused the overdose, and two, evidence showing that that heroin came from Mr. Matlock. So I want to address both of those briefly. So for the first bucket, as you just heard, opposing counsel says that the evidence was insufficient for causation given that there were prescription pill bottles and other substances found in the room. I do want to note that none of the substances in there were tested, so I do think it's an inaccurate representation to say that they were bundles of heroin. There was one officer on a body cam footage that noted that he thought that it was heroin, but again, none of those substances were tested, and the defense did not call him as a witness, and neither did the government. I also want to note that it's the government's position that any testing would have been unnecessary given numerous factors here. The victim's response to Narcan, since the jury heard that Narcan only reverses opioid overdoses, the victim's statements to both first responders and hospital staff, both members testified that she said that she used heroin prior to her overdose. And third, expert testimony on the timing and potency of heroin fentanyl mixtures, which was consistent with the timing of Miss Wiley's overdose about an hour after she ingested heroin with Mr. Matlock. Nor would the testing have shown us where the heroin came from, which brings us to that second bucket of evidence. Matlock speculates that because addicts typically have more than one source of supply, that the heroin that Miss Wiley overdosed on could have came from anywhere. But there was no evidence at trial that Miss Wiley obtained heroin from anybody else that day other than Mr. Matlock. And in reviewing her phone, law enforcement found no messages with anybody else about controlled substances other than Matlock. In fact, as Judge Pryor pointed out, there was those text messages leading up to that transaction, which required Miss Wiley to drive across state lines to Mr. Matlock's residence in Evansville, Indiana, to obtain the heroin. From start to finish, that transaction took almost 2 hours, which supports a reasonable inference by the jury that Miss Wiley wouldn't have taken such drastic measures to obtain heroin from Mr. Matlock if she already had it in her house. And the historical cell data also showed that after she ingested the heroin with Mr. Matlock, she drove directly back to her house in Kentucky. After Wiley recovered that evening, as your honors aptly pointed out, the first person that she texted when she was recovered at the hospital was no one other than Mr. Matlock, saying that she overdosed and told him to be careful. Notably, Mr. Matlock did not deny supplying her with heroin, and he also didn't suggest that she obtained it from any other source. Instead, he expressed concern and said he didn't want that to be on his conscience.
Do we have any evidence, Mr. Oliver, about from experts about dosages or time responses to different dosages and so on, or are we just kind of at sea here?
Your Honor, I don't believe that there was testimony regarding the dosages, but there was testimony regarding the responses. Forensic pathologists and toxicologists both testified that the maximum impact of fentanyl can take some minutes to about an hour.
Well, is the theory that this was fentanyl contaminated?
That's correct, Your Honor.
But we don't have that tested, so, okay. So I guess I'm just trying to, I was ideally hoping there might be evidence, is 0.2 gram of heroin shared between two people, which was, I think, Matlock's testimony. Is that enough for this kind of a response? Does it necessarily tell us either he's wrong or it wasn't pure heroin or what? And I gather the record leaves us kind of at sea.
I think so, Your Honor. But I think that this court's decision in United States v. Hardin, which I know you and Chief Judge Sykes are both intimately familiar with, having served on the panel in that case.
We've been on a lot of panels.
Yeah.
So.
But just to touch base on the facts in that case, the defendant distributed heroin to middleman A. Middleman A then distributed heroin to middleman B, and middleman B then distributed heroin to the victim. Later, or the next morning, that victim was found dead in his bedroom, and this court held that the evidence was still sufficient in that case, despite conflicting testimony about what you just touched on, Judge Hamilton, regarding dosage, lack of dosage testimony. There was conflicting testimony about whether, the timing of those distributions between middlemen. Here, I think we have a much tighter timeline. We have a defendant that admitted to distributing heroin directly to the victim, and so I think that this court's holding in Hardin supports what the government's asking for in this case.
In your brief, Mr. Oliver, the government argues that in essence we should rely on evidence from Ms. Wiley's fatal overdose 2 or 3 months later to help uphold this conviction on the serious injury result. And I guess I have trouble following that logic. What does that look like in detail?
Well, Your Honor, I think the jury was free to consider all evidence that heard during the trial, and it wasn't like the government announced at the beginning of any.
Well, I know you were pursuing the other claim, and that was where most of the evidence was, and the jury acquitted on that, right? So
That's correct, Your Honor. But I guess my point is that we didn't announce at the beginning of any witness's testimony that this only pertains to count 1 or count 2.
Right.
And so I think the jury was free to consider that, especially with regard to the pattern of distribution testimony that further supported the jury's inference that Mr. Matlock was Mrs. Wiley's supplier.
Well, yeah, but given, I mean, there's no dispute about that, right? Matlock admitted as much with respect to the December incident. So I don't know what the February evidence gets you.
I think it just helps support the inference, Your Honor, that this argument that there was potentially additional heroin in a room that came from some anonymous source of supply. I think that evidence, although I agree that the text messages and his admissions are the stronger evidence, I think it...
Without the text messages, I think you've got a much tougher case. Can I ask just one other feature of this case that struck me as very unusual is we've got a user, an addict, with unused controlled substances in her room. We don't usually see that with people who are users, do we?
I think...
I guess you say we don't know what it was, but...
That's correct, because I believe the testimony at trial, Your Honor, was only that it was believed to be largely marijuana,
right,
and that there was this foil that was next to her. But I don't believe that there was any testimony that there was actually other heroin in the room. There was just unknown substances found in the room.
When there's only a passage of 15 or 20 minutes after she returned home.
I'm sorry, Your Honor?
It was only about 15 or 20 minutes after she returned home that she started experiencing OD symptoms, right? Her mom found her.
That's correct, Your Honor. And I think that was still consistent with the expert testimony regarding the timing of that impact of the heroin she ingested with Mr. Matlock about an hour earlier. So again, I think that this court's decision in Hardin supports what the government's asking for today. To the contrary, I think that if the court were to adopt what Mr. Matlock is asking today, I think it would be setting a dangerous precedent, holding that essentially that the government would have to disprove every other potential cause of the overdose or every other potential supplier rather than proving Mr. Matlock's guilt beyond a reasonable doubt. That's not the law, and that's not the standard that the jury was held to in this case. I think it's also important to note that the jury did not just act as a rubber stamp in this case. I think that the fact that they acquitted on count 2 shows that they assessed this carefully and they considered the evidence before them. And so, again, I think that shows that the jury carefully considered all the evidence before them. So I think that the victim's response to the Narcan, her statements to both first responders and hospital staff, and the historical cell location data show that heroin was the cause of, or an expert testimony was the cause of the overdose, and the defendant's statements, his text messages with the victim, and the historical cell location data show that all point to Mr. Matlock as a source of supply. And so, unless Your Honors have any further questions, the government would respectfully request that this court affirm the jury's verdict and uphold the conviction. Thank you.
Ms. Christensen, you can have some extra time. You used almost all your time.
It's always a dangerous offer. I think first about the bundles of what I'm calling heroin, officers know what heroin looks like. I put pictures in my brief, and I think that those of us in this room who are involved in these kind of cases know what heroin looks like. It's certainly not marijuana. I'll tell you that much. I will also note that Wiley left her home in the afternoon and was in Henderson, Kentucky at 4:47 p.m. It's a significant amount of time before she's at Mr. Matlock's home at 7 using with him. Then it takes her about half an hour to get home. I place that about 7:40. Her mother doesn't call her mother doesn't tell her brother to call until 8:27. So it's a little bit more extended period of time than the government would have you believe. If it wasn't heroin, I guess it's hard to know if it's not tested. Yeah, and they can say it's not heroin, but it wasn't tested. And if they're going to rely on an investigation that doesn't test and thoroughly investigate all of the possibilities. They don't have to disprove everything, but they do have to prove that her bodily harm resulted from Mr. Matlock's heroin use with her. Unless the court has further questions, I ask to reverse and remand.
Thank you. Our thanks to both counsel. We'll take the case under advisement. And our last case for argument this morning is Rivas Jarquin versus Garland. Mr. Buzinski?
Good morning, Your Honors. Budzinski for petitioners. Two issues in this case. The first is whether there's a pattern or practice of persecution in Nicaragua. The second is whether this same evidence supports the more stringent burdens for withholding of removal and protection under the Convention Against Torture. The meaning of the phrase pattern or practice has been developed through case law, and it means a systematic, pervasive, or organized effort to kill, imprison, or severely injure members of the protected group. When this is shown, the asylum applicant does not need to show that he or she would be singled out for persecution. One obvious example mentioned in Banks is the persecution of Jews by Nazi Germany. But the level of persecution does not need to be this extreme, and it cannot obviously be an impossible standard to meet. In Gabrihivat, the Third Circuit took a look at religious persecution in Eritrea. The claim was rejected by the agency because the petitioner had never experienced problems related to his faith, and because his brother had remained in Eritrea without any problems. The petitioner, however, documented his claim with a State Department report and other articles, which showed incidents of the government breaking up Pentecostal weddings, arresting Pentecostals, locking children in shipping containers for carrying Bibles, arresting hundreds of adults from disfavored religious groups, and torturing members of disfavored religious groups until they signed statements repudiating their faith. The Third Circuit concluded that these materials could easily demonstrate an objective basis for a well-founded fear of persecution, and this was so despite the fact that the petitioner and his brother had never experienced any harm. In Tegan, the Eighth Circuit reversed the board, where the Ethiopian government kept political parties fractured by requiring them to organize along ethnic lines, and suppressed opposition by systematically persecuting leaders. In Bromfield, the Ninth Circuit reversed or held that there was a pattern or practice of persecution of gay men in Jamaica due to a statute criminalizing homosexual conduct and widespread targeted violence against homosexuals. Here, we have similar facts. The Nicaraguan government was responsible for more than 325 killings in the 2018 pro-democracy uprising. 2,000 were injured, hundreds were illegally detained, tortured, and disappeared. More than 80,000 were exiled in neighboring countries. The government did not take steps to investigate or prosecute those responsible. Instead, it actively strengthened impunity for human rights abusers and carried out a campaign of harassment, intimidation, and violence towards perceived enemies of the regime. By August 2018, the government instituted a policy of exile, jail, or death for anyone perceived as opposition. It amended terrorism laws to include pro-democracy activities and used the justice system to characterize civil society actors as terrorists, assassins, and coup-mongers. Articles in the record also indicate that this included doctors and other healthcare professionals who treated injured protesters. Rivas's family owned and operated a pharmacy in Managua. She provided medical supplies and money to a doctor who was treating injured protesters. She also provided these items to others and to a church. This doctor had to flee, and he's now in Costa Rica. Rivas did all of this to support the protesters. She supports an opposition party in Nicaragua, the Constitutionalist Liberal Party. Her brother, Saul, participated in the protests and also fled Nicaragua along with another sibling. This situation is akin to the situation in Gabrihivat, Tegan, and Bromfield. Much like Bromfield, the statute targeting homosexual conduct, Nicaragua amended terrorism laws to include pro-democracy activities. Much like Tegan, Nicaragua is suppressing opposition by systematically targeting them. The situation is sufficiently extreme, and it's not undermined by the fact that Rivas's mother remained in Nicaragua without harm. Gabrihivat's brother also remained in Eritrea. The Third Circuit still concluded that similar evidence could easily demonstrate a well-founded fear.
Well, Mr. Budzinski, obviously the question is not the sufficiency of evidence.
Right.
You've told us in your brief, I gather it's outside the record, that Ms. Rivas's mother later left the country, which basically triggered a series of thoughts in my mind about whether even if this denial is affirmed, is there an avenue for changing country circumstances? To take the historical precedent of Nazi Germany, somebody applying for asylum in 1933, whose case was being adjudicated, let's say in 1938, by then the situation had changed drastically.
Yes, so with the changed circumstances, the immigration court and the board, they're going to be looking at the circumstances there in Nicaragua currently versus when Ms. Rivas was applying. And I don't think the situation on the ground there has changed sufficiently for them to grant a motion to reopen on that basis. In similar cases, what I've seen the conclusion by the board or the immigration court being is that this is more a continuation of the same circumstances and not something sufficiently changed to warrant reopening. So I think it would be a very hard case for them to try to reopen and continue with their case based on changed circumstances at this point. Moreover, Rivas's mother was not safe when she was in Nicaragua. She had to pay for nightly surveillance and she had to watch her steps. The board dismissed Rivas's contention, contending that there had only been a few isolated incidents of harm to professionals who treated protesters. Beyond this being generally dismissive of the extent of the harm here, it unnecessarily narrows the issue. The broader claim here is that the Nicaraguan government is persecuting anyone perceived as opposition. They've instituted a policy of exile, jail, or death for anyone perceived as opposition. We don't need to narrow it necessarily to medical professionals. The board also contended that what Nicaragua is doing is merely civil strife and harsh conditions. Obviously, we disagree. We believe that a policy of exile, jail, or death goes far beyond that it's certainly systematic, pervasive, and organized. And while this language comes from the case law, I think there's a normative problem here with the language as well. I think you can really throw it at any situation and it's going to stick. Well, I'm not sure what sort of persecution cannot be characterized as civil strife or harsh conditions. The language really doesn't help us define a point at which something tips into a pattern or practice of persecution. The same facts I've just discussed also warrant withholding of removal and protection of the Convention Against Torture. Respondent has argued that the Convention Against Torture claim was waived as insufficiently developed. That's not accurate. Respondent argues that the same facts also warrant and meet the more stringent burden for Convention Against Torture protection. If there are no further questions, I'll reserve the remainder of my time for vote.
That's fine, thank you. Ms. Strong?
May it please the court. Alana Young for the Attorney General. The only issue before this court is whether petitioner has shown that the record compels reversal of the agency's pattern or practice determination. She has not, Your Honor. This is a case of civil strife. This is not a pattern or practice claim. This court has again and again stated that when the record shows, as this case shows, that there's civil strife, that there's political turmoil, even when there's human rights abuses, Your Honors, that causes substantial harm, substantial hardships to an ethnic minority, a group, some of whose members may have be engaged in insurgency against the government, that does not render each non-combatant member of the minority or of the group a subject of persecution. That's the case law before.
Is there any doubt that this is this is the president's policy of exile, jail, or death for political opponents?
There is no doubt, Your Honor. But there is no doubt because we have in the State Department Human Rights Report indicating that in August 2018, the Ortega administration provided these policy of exile, jail, or death for anyone perceived as opposition. That's true, Your Honor. But if Your Honor looks at Exhibit 3, beginning at AR 291, we have August 2018 is when that administration instituted that policy. And then we look at the subsequent evidence from April, August 2019 and 2020, and we see that that policy is not as
in fact, implemented as harshly or as directly or as in fact as exile, jail or death for anyone perceived as oppositions. Instead, what we see is the general populace, medical doctors, some medical doctors, we see just people living their everyday life, them suffering from the effects, the repressions of the Ortega administration. So the evidence is showing not that it's limited to oppositions or that they're being subject to jail, exile, or death, but it's the entire population that's suffering from this repression. And that's where it's civil strife and political turmoil and not directed persecution at this group or at any of the groups. There are 3 groups that petitioner proposes. The evidence does not show a systematic, pervasive, or organized effort to kill injured, to kill, imprison, or severely detained one of those 3 groups. And that's the high standard that this court has set.
This is the same Ortega and Sandinista government that the United States government sought to undermine through the arms for hostages deals in the 1980s?
Yes, Your Honor, it is. It is, Your Honor. However, this court has held that the pattern or practice claim is a very fact-intensive inquiry, and we look at the record in the case. The record in this case does not show, unfortunately, there is human rights abuses that the general populace or a large segment of the populace does experience, but that doesn't show systematic, pervasive, or organized effort against one of the particular groups.
Are there any groups from Nicaragua that the U.S. government accepts as sufficiently threatened at this point that their members are entitled to asylum under current U.S. law?
We don't have that information in the record, Your Honor. What I can tell you is the U.S. government does have a temporary protective program, TPS, and Nicaraguans, Hondurans, El Salvadorans, not Mexicans, are entitled to TPS, and that's based on different determinations that the Department of Homeland Security and different aspects of the U.S. government determined.
Did you say humanitarian parole? It's not
Yes,
asylum
it's
or
humanitarian
green
parole.
card.
Yes, Your Honor. It's different than asylum, withholding of removal, and cat protection.
Sorry.
TPS, I'm sorry.
Temporary protective status, Your Honor.
And what are those countries?
Nicaragua is concluded in them,
Okay.
Honduran. I believe the most recent ones have been if there's been the earthquakes, because of the earthquakes in Haiti. If there's a humanitarian situation, the U.S. government will permit individuals from those countries to come over temporarily to the United States. But in fact, we have extended the temporary status, TPS, for those individuals. That's not in the record here, Your Honor. What you have before you is a very high standard pattern or practice claim for supporters of protesters, opponents of the SLN, or professionals who aided in the provisions of the care of the protesters. The country condition evidence here shows civil strife and does not meet this court's high standard.
So I guess help me out. On the one hand, you seem to be saying the government's announced policy of exile, jail, or death is not actually being implemented as broadly as stated. But at the same time, you're also saying that there are much wider humanitarian and human rights abuses that affect people that affect everybody in Nicaragua.
Yes, Your Honor. Let me explain.
Both of those things are true.
Your Honor, the policy is the policy of exile, jail, or death for anyone perceived as opposition. That's what the State Department, that's the language that the State Department has, and that was implemented in August 2018. Take, for example, the other evidence in the record. One of the claims is regarding medical professionals. Medical professionals who are helping protesters or who are acting as oppositions, they're not being, some of them are being exiled, jail, or have unfortunately lost their lives, but not all of them. The reports from the country condition actually show that the medical professionals are being fired, unfortunately, from their jobs for treating protesters, or they're suffering other repercussions because of their act of supporting the protesters. It's not blanket
exile, jail, or death for anyone perceived as opposition. The country condition evidence, the evidence in this record shows shows different levels of harm, threats, intimidation to different parts of the population, and not specific to opponents or FLN supporters of protesters or professionals who are helping medical care workers. That's the claim group. Those are the three claim groups that petitioners are proposing, and the evidence shows more than that. It shows civil strife, political turmoil. There are human rights abuses that the general population is experiencing. Your Honor, I direct you to Krishna Pillai. That is the government's best case. It explains the pattern or practice claim and the standard before this court. It's a fact-intensive inquiry. It explains what, even though a population is experiencing human rights abuses, even though a substantial part of the population is experiencing hardship, that doesn't mean that they've established that it's systematic, pervasive, or an organized effort to kill, jail, or severely injure that segment of the population. Unless the court has any other questions.
Thank you.
The government rests on its brief.
Mr. Buzinski.
Two quick points. First, there's some discussion about this situation affecting the general populace. That's not accurate. The government supporters are not suffering any persecution. It's only opposition to the government. Additionally, unless something changed recently, TPS is not available right now for Nicaraguans. My clients cannot apply for that. I do believe humanitarian parole is available for Nicaraguans, but that's not a permanent solution. They can come to the United States, but if they want to stay here, they're going to need to find some other way to do that.
So those are two different things? I thought they were just different ways of referring to the same program.
TPS is temporary protected status. Parole is an alternative to a lawful admission to the United States
Right.
for someone who doesn't have a visa, for example.
Right, and you have to apply from outside the country?
Yes, well, you could
Usually?
do both. Usually.
Oh, okay.
Yeah. If there are no further questions.
Thank you.
Thank you.
Our thanks to both counsel. We'll take the case under advisement, and that concludes today's calendar. The court is in recess.